You're watching breaking news coverage from 13 on your side. Right now, we're bringing you the latest developments in the murder case against former Grand Rapids police officer Christopher Schur, who is accused of killing Patrick Lyoya last April. Attorneys representing the former officer are asking the judge to dismiss the case, while the prosecutor is urging the judge to allow the case to go to trial. The hearing to decide what happens next is moments away, where the judge will either issue a ruling today or will announce her decision at a later date. Stay with 13 on your side as we continue to cover this story on air, on 13onyourside.com, and on our news app and on 13 Plus.
Are you arguing this motion, Mr. Borgia?
Yes, good morning, Your Honor. Matt Pagula on behalf of Officer Schur. With me today is Kelly Hamilton and Mark Dodge. And I'll be arguing.
Okay. And we're here on defense motion to quash, bind over, and to dismiss the charge against the defendant. I did receive the motion in brief, which I'll state for the record that it did, because it's part of what the people's response included, but the motion did exceed the page limit without prior approval. However, I did still consider the motion in its entirety, but I did not consider the reply brief that was filed by defense, so I would like to give you an opportunity to reply orally to the people's response.
Thank you, Your Honor. I appreciate the opportunity, and I apologize we filed too long of a brief. It's a really an unusual case in the sense that there is no statute here that's governing when it's justified, in this case for Officer Schur to use deadly force, which led to the length of the brief. I mean, we went into the sort of the history of the common law, because the common law applies. And I think the district court, recognized, as the prosecution did in its response, that the common law is controlling here. And I think the legislature has left all of us in a bit of a quandary here because they haven't acted. There's no statute governing when a police officer or even a private citizen can use deadly force or be charged with a crime. At least there wasn't for a long time with regard to private citizens. So you have to look at the common law. And in the response, the government, the prosecution, has a different interpretation of what the common law says. And the district court, Your Honor, as the court is aware, looked at the law from 1846 and went back to 1846 and asked, whether that law that it applies today or should apply today. And I think the district court did. If you commit a felony and you try to escape, in 1846, as it is today, the arresting person can use deadly force. It's the common law fleeing felon rule. And there's classic examples of this in history. And we didn't point these out in our original brief. But in response to what the government is saying, what the prosecution is saying, I'd like to go into that a little bit because I don't think it's clear that, at least to the prosecution, that common law from 1846 still applies today. There are two elements that relate to justification under the fleeing felon rule. It's a felon, someone who's committed a felony, and someone who's fleeing. And the prosecution has added a third element, if you will, that the nature and type of deadly force used is limited in some way. Either it's reasonable or it's limited in weight or how it's used. So the classic example of this from 1846, Your Honor, is there used to be wanted dead or alive posters in this country. And I'm only talking about this because that's the law we're looking at. In 1846, people were wanted dead or alive. And that did not mean that you could just go out and kill them. So there is some limitation on this law of justification. What that meant was that if they're fleeing and they're a felon, you can use deadly force. The classic example is Jesse James, a notorious bank robber.
And I'm going to stop you only because I believe that much of what you're arguing was contained within your motion in brief. also, because frankly, I agree that the common law rule or fleeing felon rule is still in effect to some degree. So I do agree with you with regard to that argument. And so, but I don't need to hear about Jesse Dickinson.
Well, I don't want to try to.
Understand that argument.
I don't want to try the patience of the court.
And how it's evolved over time. So.
If perhaps the court has any questions about the prosecution's argument that it has evolved to a way to be in line with the U.S. Supreme Court decision in Tennessee v. Garner, where there's these application of sort of a civil standard on the fleeing felon rule. I don't know if that's where the court's inclined to go on this, but here what the district court did and where the district court erred is the district court said that they considered only the moment in which the shot was fired, the instant the shot was fired, to determine whether or not they were actively fleeing. And I think that was error. I think that the court should have looked at the totality of the circumstances, everything leading up to that. And the prosecution maintains, and the district court accepted, that this court and ultimately a trier of fact need only determine whether or not in that photograph of time deadly force should have been used and whether it was reasonable to use it just at that moment. And I think that was there. Your Honor, I also want to address with regard to the sort of the third method of justification. Because in our briefs, we indicated there's the common law fleeing felon rule and also the use of force in response to force. But there's always the justification of self-defense. And here, the prosecution maintains that it's a subjective standard. And the court agreed with that as well. The court's reasoning was a reasonable juror could find it justified only if the defendant honestly and reasonably believed his life was in imminent danger, whether that there was a threat of serious bodily harm, and it was necessary to exercise deadly force to prevent such harm to himself. And that's the self-defense standard, but that's not the standard that should be used with a police officer who's acting in the line of duty for a lawful arrest. So essentially what the district court did and what the prosecution wants this court to do is hold them to a lower burden than the plaintiff's attorneys are going to have in a civil case. Because in the civil case, the plaintiff's attorney must establish by a preponderance that no reasonable officer, given the circumstances, could believe that he was in fear of great bodily harm or death. It's not a subjective standard or test. In other words, we're not going to look at what Officer Scher had in his head and think, am I in fear of harm or great bodily death, or great bodily harm or death? It'll be an objective, reasonable officer standard. But that's not what the district court did, and that's not how they viewed the evidence. And that was error. And so it's unclear, because from what we can tell, no officer's been charged with murder for making a lawful arrest, whether or not what the standard's going to be.
You said that no officer.
I'm unaware of any officer being charged with murder in the second degree for making a lawful arrest.
But they can't make a lawful arrest if the person's deceased.
He certainly was making a lawful arrest. He had committed several felonies up to that point. And everybody, at least at the preliminary exam, agreed that he had committed felonies.
I believe running from the police officer is a felony.
Yes, and resisting and obstructing as well. Disarm.
That's the same felony that I was referring to. If you run, resist, obstruct, then that's a felony. So.
Disarming a police officer is a felony. So here, I don't think that the prosecution argument that we should treat Officer Scher the same as a private citizen who happened to get in a fight on his front lawn. The court should look at it as whether they show by probable cause that no reasonable officer, given the circumstances of the case, could believe that he was in fear of great bodily harm. Not whether Officer Scher individually held that belief. And the evidence at the prelim was overwhelmingly in favor of the fact that a reasonable officer could find that. And the prosecution didn't put on any evidence. They played a video and said that because he was shot in the back of the head, no reasonable officer could have found that deadly force was necessary in the instant the shot was fired. You had the captain of the police department testified that Officer Scher followed his training. He was justified in making the arrest. He had committed, Loyola had committed several felonies. Officer Scher had followed the continuum of force as he was trained to do to make an arrest. And that the only finding of misconduct that followed the shooting was that the prosecutor charged him with murder. So nobody has said that he has violated any training or policies after reviewing the video. And so under the prosecution's point of view, adopted by the district court, it would be easier to convict him of murder than it would be to sue him and win successfully. That can't be the law. Unless the court has any other questions, I'll rest on brief.
Thank you. And Mr. Becker, did you have anything that you'd like to say in response to Mr. or reply to your response?
I'll keep it brief, Your Honor, because I know the court has read both briefs and has paid attention to this case. You know, I think the biggest thing, the issue that, you know, we're speaking the same language, but it's clearly we have complete different interpretations. You know, they actually are arguing that there's two different states of law. You have a law for a civilian and a law in Michigan that applies to a police officer, and that's just simply not the case. I mean, you read the cases, and we've cited them in our brief, People versus Doss regarding the fleeing felon. Doss is a Michigan Supreme Court case from 1990, citing a case from 1930, saying fleeing felon, you know, police officers and civilians have to use reasonable force and only use it when necessary. The same holds true, that was Couch. Doss is on the same provision on self-defense. I mean, there are we don't have two different levels of law. Civilians and police officers are covered by the same law in the state of Michigan. This isn't 1846. This is 2023. The common law has evolved. The common law has evolved through the decisions of the Supreme Court, and we've cited overwhelming number of decisions in the Michigan courts that say police officers are held to the same standard. Force must be reasonable under the circumstances. It must be immediately necessary. And that essentially is a jury question, and that's what the district court said. This is a question for the jury. We've established all the elements of secondary murder. The fourth one, you know, was it necessary? Was it justified or excused because of the deadly force? That's the one this whole case resolves on, and that is a question for a jury. And there's overwhelming evidence that was presented at the district court level that the judge relied on, I think correctly, to bind this over for trial, so there's no basis for this court to quash. Thank you.
Well, in addressing this motion to quash, bind over, and dismiss the charge against the defendant, there was not only challenges with respect to the various defenses that are available to the defendant, but there was also a claim that the statute is void for vagueness. So I'm going to address that argument, even though it was offered last. I'm going to address it first because it's potentially dispositive. According to the defendant's motion in brief, the argument is that the criminal statute with respect to second-degree murder is void for vagueness because it fails to give a person of ordinary intelligence reasonable notice that his or her behavior may be unlawful. However, the true challenge that the defense has is not to the statute, but rather to the element of without justification or excuse. And that particular element is not in the statute, and that would be MCL 750.317. Rather, this element is listed as an optional fourth element in the model criminal jury instruction for second-degree murder. Specifically, it states the third element in the instruction that the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. And after that particular element, there's a use note that states that that particular element may be omitted if there's no evidence of justification or excuse, and that there are justification or excuse instructions that could be inserted, but they're more commonly given at a later time. These are jury instructions. In People versus Caviani, which is a Court of Appeals case, the Court of Appeals stated that a statute is not vague when the meaning of the words in controversy can be fairly ascertained by reference to judicial determinations or even the words themselves if they possess a common and generally accepted meaning. Furthermore, a statute is presumed constitutional unless its unconstitutionality is clearly apparent. Here, again, the constitutional challenge is to an element of second-degree murder and not the statute, so it fails in that regard. And even if that element was in the statute, the meaning of the words justified, excused, or done under circumstances to reduce it to a lesser crime can be easily, those words can be easily ascertained and do have common and generally accepted meanings. Therefore, the element is not vague at all. According to MCR 6.110, if on proper motion, now I'm going to move on to the other issues. If on proper motion the trial court finds a violation of this rule, which would include conduct of the examination, exclusionary rule violations, probable cause finding, or discharge of defendant, if on proper motion, if I found violation of those particular paragraphs, I must either dismiss the information or remand the case to district court for further proceedings. In that regard, for purposes of bind over, the district court has to determine whether there is evidence sufficient to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief that this offense was, or this killing was not justified under the law. Again, the elements of second-degree murder are that there is a death caused by an act of the defendant with malice and without justification or excuse. These elements essentially, especially the last element, is a judicial construct cited in People versus Bailey, which is a Michigan Supreme Court case. And the district court stated in his written opinion that there is no real question concerning the first three elements. And he pointed to the evidence presented at the preliminary examination, specifically video and testimony from the county medical examiner. And the parties agree with respect to those first three elements. The district court also said that the defense raised the theories of self-defense, appropriate force in response to force used by the decedent to avoid arrest, and the fleeing felon rule as bars to a finding of probable cause with respect to this fourth element. In this motion, the defense claims that the district court erred as a matter of law regarding the common law fleeing felon rule because the district court added an element of reasonably necessary and considered only the moment of the shooting in finding probable cause that the defendant's actions were not reasonably necessary. Second, the second claim is that in holding the common law is not a distinct theory of justification from self-defense, the district court judge made a mistake. And finally, in applying the civilian self-defense rule to an officer and probable cause that the defendant did not act in self-defense with no evidence of non-justification. That is the third argument put forth by the defendant in this motion. The defendant further alleges that in doing so, the district court abused his discretion. The district court judge abused his discretion. Once a criminal case has been bound over and jurisdiction has been vested in the circuit court, there are only limited circumstances in which the circuit court may properly remand the case for a new or continued preliminary examination. And it follows logically to dismiss the case in its entirety. That's under People v. Taylor, which is a Michigan Court of Appeals case. That case goes on to say that if a motion to quash is filed and the circuit court determines that the evidence is insufficient to support the bind-over, then the circuit court is permitted to remand the case for further examination, at which the prosecutor may seek to remedy that shortcoming in the proofs that they needed to establish probable cause. The law is clear that a reviewing court, which is this court, may not reverse a judge's bind-over decision absent an abuse of discretion. That's People v. Yost. And abuse of discretion is found only where an unprejudiced person would say there is no justification or excuse for that ruling, and that's under People v. Orzane. The Michigan Supreme Court in People v. Hunt held that the function of a preliminary examination is to determine whether there is probable cause, and a preliminary examination also helps to satisfy the constitutional requirement that the defendant be informed of the nature of the accusation against him. In this case, it appears from argument and from the motion in brief that the defendant believes the purpose of the preliminary examination to be different for him as a police officer. It appears that the defense believes that since they called a witness, which would be Captain McCursey of the Grand Rapids Police Department, since they called him and he testified about policy and procedure, and he made a factual determination that the defendant was justified in his actions on April 4th, 2022, that testimony and that factual determination by that officer negates the probable cause evidence that was presented by the people. This court disagrees. In fact, in researching cases provided by both sides, and specifically People versus Fielder, it is likely that an error was made by the district court in this case by admitting and allowing testimony about the policy of the Grand Rapids Police Department and law enforcement standards, because these policies, again, according to People versus Fielder, those policies cannot supersede the common law fleeing felon rule, which is also what the defense is arguing, which I'll discuss that later, that about the fleeing felon rule. As such, these policies were inadmissible evidence at the time that they were presented. The arguments put forth by the defendant all have to do with his possible defenses to the crime with which he is charged. And that's the arguments put forth in this motion. And it was not incumbent upon the district court to decide if those defenses are viable or not. In fact, most of the arguments in defendant's motion and brief support the district court's decision that there are definitely questions of fact that are better left for a jury to determine. In People versus Carlin, the Court of Appeals stated that evidence regarding each element of the crime or evidence from which the elements may be inferred must exist. And when the evidence conflicts or raises a reasonable doubt concerning guilt, there are questions for the trier of fact, and the defendant should be bound over. Furthermore, if the evidence introduced at the preliminary examination conflicts or raises reasonable doubt about the defendant's guilt, the district court has no choice but to allow the fact finder to resolve this at trial. And that's according to People versus Hudson. And in People versus Greer, the Court of Appeals explained further that if there is credible evidence to both support and negate the elements of the crime, it is the jury's job to determine the facts. And in its opinion, the district court judge painstakingly explained not only the basis for his finding of probable cause, but he also addressed the theories raised by the defense at the preliminary examination. Although I do not believe it was necessary for him to perform these analyses analyses on these potential defenses, no more than he would an alibi defense, or if there was a challenge to the cause of death, or if there was an issue with identity. He wouldn't go through that extensive of an analysis in determining whether or not there was probable cause. So I believe that he really went above and beyond in his opinion. But because he did that, I will respond to the issues that were raised in the motion with respect to the district court's analysis on these issues. Again, the only element at issue excuse me, is without justification or excuse. There are several claims made in defendant's motion and brief. First, with respect to the fleeing felon rule, the defense argues this was adopted in the 1800s and it clearly does pertain to civilians. And furthermore, the defense in its motion and brief states that the district court incorrectly added a prong that the element that deadly force had to be reasonably necessary, and that the court was wrong by considering only the instant of time of the shooting to say that the defendant's actions were not reasonably necessary. According to defendant's brief, and he also stated it here today, the defendant is and should be held to a lower reasonable belief standard because of his training and legal authority as a police officer. And in the brief, they cited People versus Whitty. In that case, the Court of Appeals stated that it appears that the common law imposed a further distinction between police officers and private persons when the matter escalated beyond the issue of making the arrest to the question of when deadly force could be used to make the arrest. They add later that a police officer was justified in acting on the basis of reasonable belief. And they further state that, in a footnote, that an arrest is justified only if the person to be arrested has actually committed a felony, and that's regarding private person arrest, and that's under MCL 760.16. The arrest is justified only if the person to be arrested has actually committed a felony. As such, there is presently no further distinction between officers and private persons regarding the use of deadly force in making a valid arrest. However, whether it's reasonably necessary, as the defense argues the district court stated, or reasonable belief, which is the defense position, either way, these are questions for the jury to decide. It was not incumbent upon the district court judge to decide which of these apply. Either way, whether it was reasonably necessary or whether the defendant had a reasonable belief, the jury would need to decide that. In People versus Couch, which is a Michigan Supreme Court case, the court there decided that it, meaning the court, need not resolve their authority to modify the common law rule. However, because they found in any event that the presumption of legislative adoption is in this case affirmed by 50 years of legislative acquiescence in the court's decision in People v. Gonsler. And in that case, the court approved the trial court's instruction that both officers and private persons seeking to prevent a felon's escape must exercise reasonable care to prevent the escape of the felon without doing personal violence. And it is only where killing him is necessary to prevent this escape that the killing is justified. And if a killing is not justifiable, it is either murder or manslaughter. And in their view, even if the defendant were a police officer, Garner, Tennessee versus Garner, which was alluded to by the defendant in this oral argument a few moments ago, Gardner could not apply directly, and that would require, if it was applied directly, that would require, in effect, two different definitions of murder. One for police officers and one for the rest of us. And such a scheme could raise a significant constitutional question. This is precisely what the defense is suggesting that the court and the legislature do, which is to create a separate definition of murder for police officers and for the rest of us, which would in fact be potentially unconstitutional. Moreover, that court stated that they failed to see how Garner could be applied directly in any event, since the court in that case concluded, and this is Garner, concluded only that the use of deadly force to apprehend a fleeing felon who posed no harm to the officer or others was unreasonable for purposes of the Fourth Amendment. In other words, Garner was a civil case which made no mention of the officer's criminal responsibility for his unreasonable actions, which is why it wasn't applied directly to the case that I'm referring to. Again, the higher courts are using the words reasonable care, justified, unreasonable, words which a fact finder will have to determine whether they are present in this case or not, and they would have to make that determination at a trial. As recently as 2020, in People v. Lawrence, which is an unpublished Court of Appeals opinion, the court stated that our Supreme Court has recognized that deadly force may be used under some circumstances to apprehend a fleeing felon, and they state that citing Couch, and that's as reasonable as recently as 2020. Ironically, the most applicable case that the defendant does point to in its extensive brief is People v. Fielder. And in that case, a Benton Harbor police officer shot and killed a man who he suspected of murder. However, the fleeing person that he shot was not the actual murder suspect. The district court in that case found Mr. Fielder over for trial, and the circuit court, which would be my position in that case, the circuit court ruled that, and I'm not saying this is my position or my opinion right now, but in that case, the circuit court, when he had a motion like this in front of him, ruled that no crime was committed because that court found that the defendant's killing of the decedent in that case was justified under the common law fleeing felon rule, which is what the defendant is suggesting that I do. The circuit court, therefore, in that case, granted the defendant's motion to quash, and after that, the prosecution appealed that decision, and the Court of Appeals reversed. And in their opinion, reversing that decision to quash the bind over and dismiss the case, they stated that in determining that the defendant's killing of the decedent was justified under the common law fleeing felon rule, the circuit court found that the defendant reasonably believed the decedent was the murder suspect and that the defendant was justified in using deadly force. In doing so, the circuit court in that case resolved conflicts in the testimony and substituted its judgment for that of the district court, which again is what the defense is asking me to do here. The court found whether the defendant in that case was justified in believing that not only that the decedent was the murder suspect, but also, and they use word and in using deadly force, were questions for the trier of fact. Interestingly, the Court of Appeals in that case did agree with the circuit court in one respect, and that is that, and they state in Washington v. Stark, which is a Court of Appeals, Michigan Court of Appeals case, that court, the same court that did this People v. Fielder opinion, stated that they held that evidence of the shooting policy of the Benton Harbor Police Department was inadmissible because it could not supersede the Michigan common law fleeing felon rule, which I mentioned earlier. Also, Washington was a civil case. Even though Washington is a civil case, its holding is equally applicable to a criminal case. Therefore, the circuit court correctly held that the evidence of the shooting policy of the Benton Harbor Police Department was improperly admitted at the preliminary examination, which is why I stated that that perhaps was an error that the district court did make. However, it did not rise to the level of quashing the information in that case, nor do I believe it does in this case either. Next, the wrong burden of proof under the Self-Defense Act, where is the next argument where the defendant states that evidence supports a finding that the defendant acted as a reasonable officer and the prosecution failed to show that he was not in fear. of great bodily harm or death. Again, these are questions of fact. They're not questions that the district court or myself can determine whether or not the defendant acted reasonably or whether he was in fear. These are questions of fact for a jury. Furthermore, in People v. Dawes, the Supreme Court held that, like the private citizen, the police officer who claims self-defense must have reasonably believed himself to have been in great danger and that his response was necessary to save himself therefrom. And in People v. Oster, this rule is reiterated as follows. Not only must the defendant believe himself to be in great danger, but that belief must also be reasonable under the circumstances. Again, whether or not it was reasonable under the circumstances is for a fact finder to decide. And finally, the defense argues that the district court was wrong because of his analysis under the Self-Defense Act, and that the common law, stating that the common law was not distinct from self-defense. However, this analysis must be made and can only be made by applying the facts presented at a trial. Having stated all of this, the circuit court should not substitute its judgment for that of the district court, and I'm only allowed to reverse if there's an abuse of discretion. That's under People v. Lopez. A reviewing court may not reverse a judge's bind-over decision absent an abuse of discretion. Again, that was People v. Yost. And under People v. Orzane, which is a Court of Appeals case, abuse of discretion is found only where an unprejudiced person would say there's no justification or excuse for that ruling. Here, the question before this court is only, did the district court abuse its discretion? And this court finds that it did not, and the case will proceed to trial. Right, thank you.
May I ask a question of clarification?
Sure.
And I promise I'm not going to argue about the law. I just had a clarifying question. When you indicated it was error to admit evidence of policy and training and whether or not Officer Scher followed his training, is that the court's inclination at trial, that the evidence of whether or not he was following his training is admissible?
That's not my interpretation. That's the Court of Appeals interpretation.
I guess I'm asking.
Do I have to follow them because they're higher than I am. I have to follow what the Court of Appeals or the Michigan Supreme Court has decided, unless there's some law to the contrary, or maybe there's a different aspect of it. But clearly, they held that the circuit court correctly, or the Court of Appeals stated that the circuit court correctly held in that case that evidence of the shooting policy of the police department was improperly admitted. And they state that it's not admissible because it does not supersede the common law fleeing felon rule. And I know that in that case, the policy was probably not the same as what Captain McCursey testified to. And I'm only assuming that because the circuit court sent the case, he quashed the bind over. So in other words, I did not read the transcript in that case, but I believe that he used the fact that it was inadmissible for the police department to testify to send it back. So it appears that because he believed that the officer was reasonable and the crime had not been committed, and he quashed it, that the testimony was that he should not have done the shooting, if that makes sense.
Well, indeed, the question was whether or not, because he shot the wrong person, that was the ultimate issue when it got sent back. It wasn't whether or not he used excessive force.
It was both.
Respectfully, I disagree, Your Honor, because they sent it back and they created a new rule for officers, unlike private citizens, where you actually have to shoot the right person.
I think it was just that the jury would need to decide whether or not it was a reasonable belief or not. It was not for the circuit court to substitute its judgment and say, oh, that's reasonable, sounds reasonable to me. So if I said that, hey, I believe in this case that the officer Scher acted reasonably, if I believe that and I said, okay, well, I think so I'm going to send it back, guess what? I'll just wind up back with the case again, because clearly the Court of Appeals is of the opinion that there has to be, these are questions for the jury to decide. They're not a question for the district court or myself to determine. We can't determine that. And there was probable cause put on via the video that was shown and the testimony from the medical examiner with regard to the injuries and how they must have occurred. So that's probable cause for a lack of justification or excuse. Not that you can't have a defense to it and say, oh yes, there was, but there's probable cause, which, as you know, is a much lower standard than the beyond a reasonable doubt standard. But was there probable cause? There was for that. So, and so with regard to the policy, I read directly, I didn't like make it up. I'm reading from what the case law clearly states, which is that the one thing in Fielder that the Court of Appeal did agree with that the circuit court decided was that that testimony from the police department regarding their shooting policy was improperly admitted because it can't supersede the common law fleeing felon rule. So that was the reasoning for it, and I don't know whether the policy of the Grand Rapids Police Department attempts to supersede that or not. I'm not making a determination with that. Again, I don't even believe that all of this analysis is required because of the fact that probable cause has been presented, and now the jury would have to determine what the actual facts are and whether or not it's reasonable, whether or not this is admissible would have to be a determination that would have to be made at a later time. I'm not making that decision right now. I was just referring to what the district court had done.
Yes, and we've indicated we will likely seek a leave to appeal. So the reason I'm asking about whether or not evidence could be admissible, because the court has indicated that it's not admissible. It's my understanding the court is saying that Officer Scher had to have a reasonable belief that using deadly force.
You also said that he had to have a reasonable belief, because that is the standard. In your argument, you said it's not reasonably necessary, it's a reasonable belief on the part of the officer. I agree that he has to have a reasonable belief, but whether it's reasonable, that's for the jury to decide.
So when you talk about self-defense.
Same thing. That's for a jury to decide.
So how could we possibly prove that his belief wasn't reasonable if we can't get in all the training and all the policies that he didn't violate into evidence?
Again, I'm not making an evidentiary determination at this stage. I'm saying that at the preliminary examination, as in this case, I don't necessarily believe it was admissible in the prelim. But I'm not making an evidentiary decision right now at all, because I do not have the policy in front of me. I don't know whether it comports with the fleeing felon rule or goes against it, or self-defense or goes against it. I cannot possibly make an evidentiary determination with respect to that. I was only referring to what that case said, which again, I'm only talking about because the district court decided to go that route and perform an analysis on all of the potential defense theories, which I don't believe he had an obligation to do.
I mean, I understand justification to be an element of the offense. Is that not the court's? You seem to be treating it as if it's a affirmative defense.
As if what is?
A justification is an element of the crime,
Right.
rather an affirmative defense. The court's suggesting that the only way the prosecution has to show probable cause is if, in other words, there's no way that the court can rule on whether or not Officer Scher was justified in this circumstance?
I think that he did say that there's probable cause that he lacked justification or excuse at the prelim, given the video that he summarized and the injuries that were testified to by the medical examiner. I'm simply stating that those were sufficient for a probable cause that he did not have justification.
Okay, but
I'm not saying he doesn't have a defense. I'm saying there's probable cause, not even beyond a reasonable doubt, but probably there's probable cause that there was no justification or excuse.
And the court indicates that this court should not have considered Captain McCreary's testimony?
I'm stating that according to the case law, that yes, at a preliminary stage, I don't believe it was admissible testimony at that point.
Admissible because it's not relevant, or admissible because it shouldn't be germane to his determination?
Correct. Inadmissible for a prelim in determining probable cause or not. Because he can't, whatever he says cannot supersede what the law is. So whatever the policies are, don't, for example, if the policy was, hey, you could just go shoot whoever you want in the face, that's not the law. The law does not support that.
Sure.
So to the extent that the policy violates what the common law rule is or what the law is, to the extent that that's true, and it's definitely inadmissible because it does not assist the trier of fact in determining whether or not a fact and issue is true or not.
Okay.
So.
And I'm sorry, I don't mean to try the court's patience, but with regard to the self-defense defense for justification, is it the court's holding that the only defense Officer Scher has is the same self-defense standard that a private citizen has, and that there's not this Tennessee v. Garner standard?
No, I'm not holding anything with respect to a defense. I'm simply responding to the arguments that were in the motion brief and addressing the analyses in the opinion of the district court. I'm not holding any of that.
Okay.
I'm simply saying he did not abuse his discretion. That's the only thing I'm here to determine. That and whether or not the statute is void for vagueness, which I already found that it's not. And I also find that the district court judge did not abuse his discretion, irrespective of his analysis with respect to any defenses, because he can't say, oh, well, you put on a defense in district court case, you know, there's no case. He can't do that because he has to either find probable cause exists or it doesn't. Any defenses are brought in at trial and based on the evidence at trial. In fact, that particular element is an optional element. If there's evidence put on at trial that, hey, there's justification, well, then you give that instruction. But if the evidence doesn't bear that out, then you don't even give the instruction.
So it is a defense, not an element.
What, self-defense?
So my understanding is that the prosecution has to put on probable cause.
Right, they did.
That he didn't act.
And they did so.
And it wasn't justified.
And they did so.
I'm asking for clarification on what actually the probable cause to do in what regard. I mean, so.
Okay, because you're allowed to decide using direct or circumstantial evidence. The district court, in watching the video, right, and in listening to the medical examiner, found that a reasonable person, juror, unprejudiced person could find that there was no justification given those facts. I cannot substitute my judgment for his. I can't say, oh no, he was wrong. That's not true because that's his. He didn't abuse his standard. I mean, abuse his discretion in finding that provided probable cause.
With regard to the facts, but with regard to the law, I'm just looking for clarification. Did Officer Scher have to honestly and reasonably believe in his own mind that he was in fear, or is it the standard in Tennessee v. Garner, where the prosecution has to show that no reasonable officer could have found? Because the civil standard is actually tougher than the criminal standard, and that doesn't comport with any other area of law.
And so, Garner did not make a determination with respect to a criminal case because it was a civil case, right?
Correct.
Okay. And then in Garner, they said use of deadly force to apprehend a felon who posed no harm or to the officer or others was unreasonable for purposes of the Fourth Amendment. But they didn't mention the officer's criminal responsibility in that case because it was a civil case.
Correct.
So I'm really not, all I'm doing is ruling on this motion to quash. I'm not making any evidentiary rulings. There's no evidentiary motions in front of me. Again, the only reason I'm even talking about these defenses is because the district court judge decided to refer to them in his opinion, which I find he was not required to do. It's not required under the law. If he found there was probable cause, then he found there was probable cause. I don't think that he abused his discretion in finding. So I don't believe that the evidence is just so egregiously to the opposite that there's no way he could have found that. It's just not the case.
I understand that, Your Honor. And maybe this is an argument to be made by the defense at a different juncture when talking about jury instructions, for example, because we don't know what the law is.
Exactly, and we don't know what the testimony or the evidence would bear out.
So I mean, the defense actually needs some guidance as to what the parties are going to have to prove at trial. So we'll file a separate pleading or some sort to figure out what that law is. And I understand the court's point. I appreciate the court's patience. I know we filed extensive briefing. It is an important issue, obviously, not only to Officer Scher, but pretty much every police officer, because this law, I think, because it is the first time an officer has been charged with second-degree murder in a circumstance like this, will have significant ramifications down the road. So I thank the court for its well-reasoned opinion and its time.
Thank you. All right, so if there are no other questions, go on to our next motion.
Thank you.
Thank you.
The motion to quash hearing to the People versus Christopher Scher has just wrapped up. In just moments, we'll hear from Kent County Prosecutor Christopher Becker, who is prosecuting the case against former Grand Rapids Police Officer Christopher Scher in the killing of Patrick Lyoya. Stay with 13 on Your Side as we continue to cover this story on the air, on 13onyourside.com, on our news app, and on 13 Plus.
And so, the parties have to know what exactly each side has to prove or not prove in this case. And it comes down to, when we're talking about the preliminary exam, whether or not a police officer is justified in using deadly force in the circumstances that were shown at the preliminary exam. When you have a suspect who had committed a felony, committed several felonies, that's undisputed, and that, under the common law, and I didn't get to tell my Jesse James story because the court didn't want to hear it, but okay, so I'm going to tell you now. I mean, it was a trip down memory lane, or history here, because in 1870, when Jesse James, everybody knows who Jesse James is, when he was this notorious bank robber, which most people over 40 know. There's another Jesse James apparently.
Yeah, I don't know that, Jesse.
Okay, so yeah, there's a Jesse James that my kids know. It's not the one I'm talking about. I'm talking about the notorious bank robber from the 1870s. He's going across the Midwest and the Great Plains states, and he's robbing all these banks. And so they started putting these posters up, wanted dead or alive, because he's a thorn in the side of law enforcement. And so his partner in crime, Bob Ford, sees this wanted dead or alive reward $10,000, decides that he's going to wait until Jesse takes off his pistol for the night and isn't looking. He shoots him in the back of the head while he's basically turned away from him. And then he takes the body to the authorities and says, I want my $10,000. And they said, well, that's not what we meant, and they charge him with murder. And the reason is, wanted dead or alive doesn't mean you can just kill somebody. And that's never been the defense's point of view. Wanted dead or alive when you're making an arrest means if they're fleeing and they're a felon, then you can use deadly force. And that's what the common law says. Once you establish, in 1870 as it is today, that someone is fleeing and they've committed a felony, which is undisputed here, then you can use deadly force. It doesn't matter how much deadly force you use, or whether you use your gun or the taser or a nightstick. That's not the question. And had Bob Ford, the guy that shot Jesse James, simply said he was fleeing, he probably wouldn't have been charged with murder.
Yeah, but Matt, you've argued this Wild Wild West 1846 law twice now in front of two different judges. You even said last time that you didn't think it necessarily should be the law, but the state legislature failed to act. Two judges have said it isn't actually the law, and that there is the same standard for citizens as police officers, as Becker said today. So, I mean, where is this argument going? Are we
Well,
going to see this
See,
again?
there's the interesting thing. They both said that is the law. In fact, Judge Ayub called it draconian. And frankly, most people today would agree. But what they're saying is that private citizens today, as they could back then, have the protections of the same law. And that's not right. We don't allow vigilantes to run around and chase after a fleeing felon. What do if someone commits a felony and they run away? If you're not a police officer, what do? You call 911. So the prosecutor's argument has the perverse effect of essentially saying it's okay for vigilantes to shoot people in the back. And so because they don't want that result, they're saying that police officers are held to the same standard as a random guy, a private citizen who wants to make a citizen's arrest. And that's not the law either.
But the judge said today that there should not be two different standards of murder for citizens and police officers. Isn't that not what she said?
That's what she said, but under the law, because the legislature hasn't done anything on this, what that means, if the common law still applied to private citizens, like an officer, it means you can shoot someone when they're fleeing. And that's not what the court actually said. They considered whether or not they were fleeing, and that's the question of fact.
Is it relevant if he's fleeing while the shot is fired? You know, in the video, he's on top of him, not running at that point. Will that prove to be relevant in the...
Fleeing does not mean running. Fleeing means escaping. And so, and there's two prongs to that, either escaping or using force in response to a lawful arrest. And so, you know, it's tough at a preliminary exam, but I don't know how anybody can look at that video and say he wasn't either trying to escape during the entire time or using force to try to get away. I mean, you can argue whether or not he was trying to hurt Officer Schur, but that's what we're saying is not the question. The question is whether it can't be the only time an officer can use his firearm is when he's about to be hurt. Maybe that could be the law, but that's not the common law. It's certainly not the common law in 1846.
I guess
But how do you-
the point is, you've argued the law twice now. And as a point of law, is this going to, are you going to appeal it somewhere? I mean, that's not going to be what the trial is about, is it?
I have no idea what the jury instructions are going to say. In fact, at the end of my argument, I asked the judge, can you tell us what the law is? Because there are three defenses here, basically. And it's an element of the offense whether it wasn't justified. So the government's going to have to prove at trial, if we go to a trial, beyond a reasonable doubt, that the fleeing a felon rule doesn't apply, the use of force in response to force doesn't apply, and whether or not Officer Schur acted reasonably in self-defense. He's always got a right to self-defense. And the cases that discuss this, they don't limit the officer's use of these defenses. What they're doing is limiting the use of the private citizen. Because when we've addressed this in the past, when people have been charged with murder, it's usually it's because they used too much force and they should have called the cop. All those cases that the court referred to, except for one, Fiedler, all those are private citizens. This idea that officers and private citizens should be treated alike, that comes from a 1930s case where what was had was prohibition, right? And so in this case called Gonsler, this guy's making moonshine in his garage, and it was illegal back then, okay? And someone tries to steal his moonshine. And then he claimed that the guy ran away, and because he was stealing his moonshine, he shot him and killed him. He got charged with murder. And so when it goes up to the Court of Appeals, the issue is, well, does the fleeing a felon rule apply in that situation? You have a guy who's doing something illegal, and the guy runs away, and they still held it applies, but you have to have a reasonable belief that the person that is running is actually a person, or an actual belief. So, and they have actually committed a felony. The guy got convicted. All those cases relate to vigilante justice. And if we're going to start treating the police officers as vigilantes, why would anybody want to be a police officer? This arrest was textbook, was absolutely textbook. It started with a lawful stop where the plates didn't match the car. There were lawful commands. The officer was respectful and polite and firm, which he's supposed to be. Every step of the way. Captain McCursey testified that he followed his policy and training every step of the way. And so whether or not that's reasonable under the circumstances, if that's going to be left to the jury, I hope that we get to at least put evidence on that every officer that's looked at this and reviewed it, nearly every prosecutor that's reviewed it, does not think that's murder under the law. And so that issue is going to have to be decided.
How do you justify, though, the shot in the back of the head? Trying to, with a jury, how do you get that?
It's where the deadly force is used is absolutely irrelevant under the law. The question is, when can you use deadly force, not where? So, because the reason that's the rule is because you can kill somebody if you shoot them in the back of the leg, right? Just like you could shoot someone in the back of the head and they not die. So where you use the deadly force is irrelevant. All the cases discuss when. When can an officer use deadly force? So where is irrelevant.
So moving forward, and I know you've indicated that you will appeal, but looking ahead as we stand now to a trial, in terms of a jury, there's going to be very few people to find who haven't heard of this case, very few people who may not be pressured by societal concerns. Are you fearful when it comes to the jury selection?
I'm always fearful picking a jury because I never know what they're going to do. But we'll try to get a fair and impartial jury. And I think the people of Kent County can do that. If we're going through the jury process and no one can say they're going to be fair and impartial, then we could consider moving it to another county. But right now, there's on both sides. I could see people feeling very strongly one way or the other, and they're going to be asked, can you set that aside, those opinions, and look at all the evidence and apply it to the law? I mean, the question that we're arguing about today is not necessarily the facts. We're really arguing about the law because it's still not clear. And Officer Scher only wants the opportunity to go to trial and have his day in court with the correct law. Obviously, he does not feel like he committed a crime, but right now the crime is still undefined.
So you plan to appeal today's ruling? Is that what?
Yes, we plan to seek leave to appeal. So
State Court of Appeals?
it's not an automatic
State
appeal.
Court of Appeals.
It would be up to the Court of Appeals, yeah.
So do you expect, the trial is scheduled for March, right? If you take it to the Court of Appeals, is that even going to happen? Do you expect it to start in March?
Well, the
like
court
it's
could
supposed
stay the action. I don't know if the court will or will not. No, if it were brought to an appeal, I would expect that the proceedings would be stayed and it wouldn't go on March 13th.
It seems, excuse me, it seems like the judges have agreed with you with the question is like, when is deadly force authorized? But it seems like they both interpreted that it's a question for a jury. Not that you have to get into like trial strategy or anything, but how do you plan on approaching the jury in kind of saying that Officer Scher was justified in his use of deadly force?
I think it's a good question. I mean, certainly, I think everybody knows our defense at this point. You have a suspect who flees, who doesn't get very far, and will not respond to any lawful command. And so our defense is that Officer Scher was doing his job. He was trying to arrest him for a host of different felonies. Patrick Loyola was fleeing because he did not want to be arrested. And so the law affords police officers the right to arrest somebody under those circumstances. And the law affords him the right to use deadly force under certain circumstances. We're still arguing about that, but the facts are relatively undisputed. Patrick Loyola fought with Officer Scher for several minutes, didn't listen to a single command, disarmed him of his taser. In our point of view, had the taser in his exclusive control, which is a finding that the district court already made. And he transferred it from his left hand to his right hand. And then the moment before the shot, he was rising off the ground. And so our defense is, first of all, there's the common law fleeing felon rule and the use of force and response to force, but also that he acted as any officer, and I think we only have to show a officer would have under the circumstances. Would any officer be justified in using deadly force under those circumstances? And the prosecutor has to prove beyond a reasonable doubt that no officer was justified. And so I think the prosecutor's got a tough burden in this case.
So was Patrick Loyola, fighting with him or fighting to get away? Is there a distinction there?
He's fighting with him to get away. Obviously, the officer's trying to arrest him, and he doesn't want to be arrested. I mean, you've seen the video. Looks like he's trying to get away, right? Well, you can't do that. It's a lawful arrest. And he's asking him to stop. And then he's telling him to drop the taser. The law isn't that he's, with regard to the fleeing felon rule, that he's about to hit him with the taser. That's why Judge Ayub called it draconian. Because a lot of people, and I'm not saying this is the right law or the wrong law, believe that the only time an officer should use deadly force is when it's reasonable in the circumstances to use deadly force. But we're still in 1846. So, I mean, you guys can watch the video as well as I. I mean, it appears to me that he's doing everything he can to get away, including yelling to his passenger, get the keys, meaning we're getting out of here. Or maybe move the evidence of the crime away from here, one of the two. But it's not permitted under the law that you can fight with a police officer.
In any way, do you think it'll help or hurt your case that someone was standing by recording the altercation?
It is what it is. And I'm glad that there are more recording devices these days because these things come to light more often. And, good or bad. And I think society in general is benefited by the fact that things are recorded. And so, there are witnesses too, but here you have video evidence. The video evidence actually doesn't capture the entire thing. It goes up and down, and Officer Scher's body cam goes off and on. But I think we're helped by the video evidence because while you can take a snapshot of a picture and make it look bad, the instant the shot was fired, that doesn't erase the minutes beforehand when Patrick Leoy was violently resisting arrest.
Given that you're using a pre-Civil War era law in this fleeing felon law, can you talk about the difficulties that imposes upon bringing forth this case in 2023 when we've had so much social justice movements even here in Grand Rapids, and explain does that make your job harder, the way that how low this law is?
Yes, and shame on the legislature for doing nothing when the Michigan Supreme Court in 1990 specifically called on the legislature. It's in the opinion. We're not going to decide this. We're not going to decide what's justification in these circumstances. You guys do it because we don't want to pass on this as a crime because that's not our job. The legislature makes the laws. So perhaps the legislature now that we have this situation where nobody seems to know what Officer Scher's held accountable for, or if this old law applies, whether we want it to apply, maybe they'll do something now.
Are you confident that you'll prevail at trial?
Yes. Thanks.
Thank you. Thank you.
Thanks, sir.
With an absolute air of confidence. So it was the first thing, not cockiness. The first thing I noticed, very few things in your hand comparative to the defense. What makes you so confident today?
I don't think it was confident. I thought, like the motion when we had the bind over, I think the law was on our side. I mean, I think, we prepared a good brief, and I just didn't think there was an issue that it was going to be even close. I mean, I think the judge summed it up pretty well in her decision that, the law's on our side in terms of this should be, at this stage, is of a jury question. I mean, that's what it's basically about. It's not whether, the final determination. It's whether the jury should hear the case, and we clearly believe that, and the judge upheld that today, so I think that would be the confidence, I guess.
How confident are you that a jury will decide that he was not justified?
That's going to be up to the jury. I'm not going to make any predictions on that. That's up to a jury ultimately, and we'll see.
What do you make of the judge's thoughts on police department policy and whether that could be evidence?
Yeah, I think she was saying it's kind of an interesting, splitting of the hairs, if you will. She's saying, I don't think the judge should have, dealt with it at the preliminary hearing, but she was quite clear that she's not making any preliminary determinations, saying it can't come in at the trial. So I think that was just kind of, maybe a little inside baseball in terms of, she's not saying it can't come in at the trial. So that may be something we hash out down the road, but, at this point in time, I don't think that was that big of an issue.
Well, but in terms of your trial strategy, are you going to try to get that excluded as evidence based on what she said today?
I'm not going to divulge what my trial strategy is, so.
Do you feel like the law is clear here? I mean, we just spoke with the defense. He feels like there's some.
I said that in my, my brief thing. We speak the same language, but we're not understanding each other, because I think it's, perfectly clear. I mean, it's not a close call. So, yeah, I think there's a difference, at least in our interpretation. Our interpretation is this is very clear that, police officers are treated the same.
Chris, is the fleeing felon argument circular? Because Mr. Loyola was just a traffic stop, and then the officer escalated everything to felonies. It wasn't like he's a bank robber right down the street. They keep saying he's a felon running. He wasn't. He was a traffic stop.
Well, it was a resisting opposing. Resisting opposing, he ran, he clearly ran, and we conceded that at the preliminary exam, so it's hard for us to say it's not a fleeing. He was fleeing, it was resisting, so those are issues that,
And that's a
we've got to
felony.
concede. Yeah, resisting an officer is a felony.
And this is an 1846 law, pre-Civil War era law.
No, he was talking about the common law, the fleeing felon, but that's a law, but it's been developed over time, and that's our position. It's not like we're stuck in 1846. There's been case law and Supreme Court cases that the judge cited and that we cited that have developed that law over time.
So Jesse James is not relevant here?
I don't think so.
That's my point, because he's parading him as a bank robber, fleeing felon. I mean, this is a traffic stop.
Yeah, but it's still a felony, and we conceded that, so it's hard for me to say no, it's not. I mean, we said that at the preliminary exam.
So he's still trying to argue that he thinks citizens and police officers should not be held to the same standard, because then that sort of elevates citizens to be vigilantes on the streets. Do you see any, possible bad side effects here by arguing that citizens and police officers should be held to the same legal standard for use of force?
Well, that's the thing in terms of, I think my concern is that, if police are held to a different standard, you pull a police officer says, hey, come with me, and you pull away, all of a sudden the police officer can kill you. That's stunning in its application. So I think that's the biggest thing. Civilians have always reasonable force and only when immediately necessary. I think that's clearly for civilians, and it's clearly for police too. That was our point.
Defense has indicated that they're going to seek leave to appeal Judge Elmore's decision. Do you have any concerns about the trial getting pushed back possibly, or is that just part of the process?
No, it could be. I mean, quite frankly, it could be. That's something we're going to have to see how it hashes out. March is coming up quickly, and so I'm not going to predict at any point in time what's going to happen, but that is a possibility.
Is the county at all in communication with the Loyola family? I know that they've been frustrated that the trial is taking so long. Any communication with them? We've
been in communication. That's they're our victim witness unit, and we're in communication with them at all times. We let them know this was going to happen today. They said they weren't going to show up, but we're always in contact with them, and we'll notify them what's going on, and I'll try and keep them abreast as best we can.
So no surprises today?
Not for me. I mean, I think this is kind of how I expected it to go, because I thought, like I said, I thought the law was fairly clear on our side.
Thanks, Chris.
Thank you, sir.